So the federal law which prohibits nonviolent felons from possessing firearms has once again been ruled unconstitutional after the Supreme Court's recent 8-1 decision in GVR of this case. Now, really quick before we jump into this video, I just want to mention that looking at some of my analytics, about like 58 to 60% of all viewers are actually not subscribed to this channel. So if you want to support the channel for free, please consider subscribing. Also, just leaving a positive comment here on this video helps to trigger the algorithm and lets it know that you see value in this video and it should share it to more people. As I mentioned in the intro, in this video, we need to discuss a very significant Second Amendment case that was recently decided after the Supreme Court's GVR of this challenge. The case we're going to be talking about in this video is Range versus Garland, and it was just ruled on once again by the lower court in favor of Mr. Range. This Range case involves a challenge to the federal laws which prohibit someone with a nonviolent felony or misdemeanor equivalent from being able to own, possess, or acquire firearms essentially forever. Now, this case was recently ruled on after the Supreme Court issued a decision in the Rahimi case. In the Rahimi case, the Supreme Court upheld the federal laws restricting the possession of firearms for someone who is subject to a domestic violence restraining order. So that was a federal law which prohibits temporarily some people from being able to purchase, possess, and acquire firearms. Now, after the Rahimi decision, the Supreme Court sent this Range case back down to the Third Circuit en banc panel for a new decision in light of what they said in Rahimi. Recently, the Third Circuit once again ruled that as applied to Mr. Range, this federal law is in fact unconstitutional because it violates the Second Amendment. They found that Mr. Range is still among the people mentioned by the text of the Second Amendment. That ruling by the en banc panel has now led the district court in this case to enter judgment in favor of Mr. Range. And now with the Trump administration back in control, they have the option of deciding how this case will proceed forward, or if they're going to let that judgment sit essentially forever and now be precedent in the Third Circuit. Now, for those not familiar, this Range case essentially involves the issue of an individual here losing his 2A rights forever because of some federal laws. 26 years ago, Mr. Brian Range was convicted of concealing some of his income so that he could obtain some additional food stamps for his family. Essentially, he simply made false statements on a federal form about the amount of his income so he could get food stamps. Because of that, he was charged and convicted of a Class 1 misdemeanor in Pennsylvania. Mr. Range has no other serious criminal issues, and it's just simply lying on that form that now bars him forever from exercising his 2A rights. And because of that, he challenged the federal law, which is 18 U.S.C. section 922G1, and he challenged it under the Second Amendment. Mr. Range brought this lawsuit originally in a district court in Pennsylvania against the Attorney General and the ATF. So this originally was filed against the Biden administration. He sought for the federal government to no longer be able to bar him from possessing firearms only because of that one lie that he made on a form 26 years ago. However, originally on review, the district court ruled in favor of the federal government and issued a motion for summary judgment. In doing so, the court used what is the old two-step approach. However, as we all know, the Supreme Court recently rejected that in Bruin and reaffirmed that in Rahimi. Now, after losing at the district court level, Mr. Range appealed then to the Third Circuit. On a review, a 3-judge panel in the Third Circuit issued an opinion upholding the lower court's decision, citing to Bruin. The 3-judge panel in that decision cited history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens. So the Third Circuit 3-judge panel found that his misdemeanor, although non-violent, qualified under 922G1 and therefore excluded him from the class of the people afforded the right to keep and bear arms. Well, Mr. Range did not quit there, and then he sought en banc panel review in the Third Circuit. In on review, the en banc panel in the Third Circuit found that 922G1, as applied to Mr. Range, is in fact unconstitutional. The Third Circuit found that Mr. Range is part of the people protected by that text, and since he desired to acquire a firearm for self-defense, it is also conduct that is protected by the Second Amendment. Now, after that ruling, the federal government then appealed to the Supreme Court, and they wanted the Supreme Court to reverse that decision. But after the Rahimi 8-1 ruling, this Range case was then granted, vacated, and remanded back down to the Third Circuit en banc panel for a new decision, a new analysis in light of Rahimi. My prediction after that, and after listening to the en banc oral arguments, was that the Third Circuit en banc panel was simply going to rule the same way, and that's ultimately exactly what they did. In that decision by the en banc panel, they stated that we agree with Range that despite his false statement convictions, he remains among the people protected by the Second Amendment. and because the government cannot carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulations support disarming Mr. Range, we will reverse and remand. The majority opinion stated that at the root, the government's claim that felons are not among the people protected by the Second Amendment devolves authority to legislators to decide whom to exclude from the people. We reject that approach because such extreme deference gives legislators unreviewable power to manipulate the Second Amendment by choosing a label. And that deference would contravene Heller's reasoning that the enshrinement of the constitutional rights necessarily takes certain policy choices off the table. In sum, we reject the federal government's contention that felons are not among the people protected by the Second Amendment. Heller and its progeny lead us to conclude that Brian Range remains among the people despite his 1995 false statement conviction. They then move on to the next step of the analysis, which is they state a very easy question to answer. They state that having determined that Mr. Range is one of the people, we turn to the easy question, whether 922G1 regulates Second Amendment conduct, and they state that it does. Range's request to possess a rifle to hunt and a shotgun to defend himself within his home tracks with the constitutional right as defined in Heller. Since the text of the Second Amendment is implicated and the law is regulating protected conduct, they then state that, of course, they have to rule in favor of Mr. Range and that the federal government showed no historical traditions which support this type of restriction. Now, that decision by the Third Circuit en banc panel was issued in December, and today we received the judgment from the lower court from the district court ruling in favor of Mr. Range. The order of the district court states that, and now the 14th day of February 2025, upon considering our Court of Appeals mandate following today's telephonic status conference, it is ordered that 1. To enter declaratory judgment in favor of Mr. Brian Range, consistent with our Court of Appeals holding that Congress's prohibition in 18 U.S.C. section 922G1 is unconstitutional under the Second Amendment of the United States as applied to Mr. Brian Range. And 2. Enjoin enforcement of 18 U.S.C. section 922G1 against Mr. Range only, and the district court shall close this case. So the Supreme Court's Rahimi decision, the remand to the Third Circuit, and the Third Circuit's recent ruling in favor of Mr. Range has now led to this case being ruled by the district court in favor of Mr. Range that 922G1 as applied to him is unconstitutional and needs to be enjoined. And now the Trump administration has control of this case because the Biden administration is out and the Trump administration gets to decide how they want to proceed forward in this case. The Trump administration could file for review for Supreme Court review. If granted, that would be something that would litigate. The Trump administration would have to determine what their plan would be. So they have the option to still seek Supreme Court review after that Third Circuit en banc panel decision. Oftentimes, if the federal government is the one filing the petition, the Supreme Court will in fact take those cases. Now, whether or not the Trump administration wants to do that and what form of arguments they would actually take would be interesting. Right now, with the executive order that Trump issued to protect the Second Amendment, they were reviewing all these cases and determining which ones they actually want to proceed forward with and potentially which ones they want to drop. The other option would to not seek review at all and instead let the en banc panel decision sit and let this lower court order also stand. That would then open up the door for more as-applied nonviolent felon challenges in the Third Circuit and potentially other circuit courts as well that could cite back to the Third Circuit. Now, there was a conference today and the federal government might have represented to the court that they do not intend to seek review from the Supreme Court, and that might have led to the issuance of this order because the lower court would know that the Supreme Court is not going to be asked to reverse or to review this issue, and so they could issue their mandate and issue the new order. But regardless, this is a big win for nonviolent felons and their right to keep and bear arms. And like I said, this is a decision that could lead to more cases, more challenges, more decisions in favor of nonviolent felons and their right to keep and bear arms, and lead to other circuit courts doing something similar. So now we will wait to see what the Trump administration wants to do going forward. And it could simply be that they're going to let this stand and they're not going to challenge it. And this would be solid precedent in the Third Circuit. So we're going to keep our eyes on this to see how this plays out going forward after this district court order. And if we get any more information, I will let you guys know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. Drop a positive comment here, let the algorithm know that you enjoyed this video, that you found value in this video, and that helps the system to know that they should send this out to more people and they should spread this type of Second Amendment information. But regardless, thank you guys so much for all of your support. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.